Thank you very much. Good morning, everyone. Welcome to the Supreme Court. I thank you very much for attending these virtual arguments. This is the way we've been able to move forward. We will get back into the courtroom as soon as we can. But for now, this is the safest way to do this and to fulfill our constitutional obligations. Have the parties talked about how we're going to do the time? Is there any variation? No?
I think Attorney Baer is trying to speak, but he's muted.
Sorry, Your Honor. This is Aaron Baer on behalf of the Stanford defendants. While we haven't reached an agreement, I've had conversations with other counsel about their preferences, and a number of counsel wish to address the court at least briefly. And I can let them speak for themselves, but I know Mr. Das wants to be able to speak on behalf of Rebecca Hammond. I think Mr. Esses at least wants to make a brief statement at some point. And Assistant Attorney General Osborne is here on behalf of the Secretary of the State and also wants to reserve time. My only concern, Your Honor, is I represent the defendants who have sort of the principal role here, and I'm cautious about not releasing too much of my time for argument. I would just respectfully suggest for Your Honor's consideration that perhaps some of the others, in particular Attorney Osborne, who did not file a brief and is here really at the request of the court, so that if points are made about the Secretary of State's role during other people's arguments or questions arise that the court wants answered from a representative of the Secretary of State, that at the end she would be there to be able to correct any misapprehensions or answer the court's questions. So I'm hoping that time will be in addition rather than coming out of the defendant's collective time, Your Honor.
Yeah. Well, thank you very much, counsel. I wish that you folks had, and maybe I should have done it, but gotten together and worked this out, because it would have been easier for me. I'm sure the members of the court would like to give additional time. However, on a virtual platform, we have to be very careful when monitoring the time that we're actually going to use up. How close to you are to an agreement of how you're going to work this out, or how you want to do this? Did anybody really mention timeframes?
So I'll let them speak for themselves. My understanding is Mr. Das is looking for 5 minutes of time to address the court on behalf of his client.
Okay.
I should let the others speak for themselves. We just didn't, we spoke, but I didn't get responses back sufficiently in time to sort of reach an agreement and then let the court know. My apologies, Your Honor.
No need to apologize, counsel. These are very, very strange times. I'm glad that you took the initiative to do what you did, so I appreciate that.
Your Honor, it's Josh Esses. I think two minutes would be more than sufficient if you're willing to grant it to me.
Thank you, counsel. Mr. Das?
Yes, Your Honor. As Attorney Baer mentioned, we were asking for about 5 minutes.
Anyone else?
Your Honor, the Secretary would just like to request 3 minutes, whether the court wants to make that in addition, and we may not even need to use those 3 minutes.
Okay. My fellow members of the bench, sort of unusual having this conversation out on the bench instead of in our conference room. But does anybody have an objection to prolonging the argument for this time? Okay, thank you very much. So that will not come out of.
I would like to say I think it's unorthodox to allow the Secretary of State 3 minutes when they didn't file a brief. I think she's here to answer questions, and I think that's all it should be.
I think that's all she's asking for.
I thought she was going to make a statement.
Sorry if I wasn't clear. We just wanted to set aside the time in the event that there's
questions only. Okay, that's fine.
Okay. Any more housekeeping before we start?
I guess just to clarify from the plaintiff, Your Honor, I would make sure that question time is I have rebuttal after that, as opposed to that being the end of it. So I'm assuming that's the case, but I didn't want to find out afterwards. I guessed wrong.
You don't like being surprised, Mr. Leiden? Okay, so thank you very much. So that time will be in addition. Senior Associate Justice McDonald will be keeping our time. So that time will be in addition to the 30 minutes that the parties have to argue. Okay. Some of you have done this before on the virtual platform. Some may not have. What we do is, because we're not on a physical bench, we raise our hands. Unfortunately, on this platform, sometimes you can't see people. So we'll try to raise either our hand or a virtual hand. If that doesn't work, try to get the court's attention, and then I will I'll call on you to find out what's going on. But that's how the justices will be asking questions. If you see a virtual hand or a real hand, please pause your argument so that I may ask that question and we may proceed forward. Any questions at this point? So, all right, counsel for the appellant, if you will identify yourself and tell me whether you wish to reserve any time for rebuttal, I'd appreciate it.
Good morning, may it please the court. Brendan Leiden for the plaintiff, and I'd like to reserve 6 minutes for rebuttal.
Thank you, Mr. Leiden.
The linchpin question as I see it is whether an elected office being occupied by someone who was not elected is a matter of any constitutional import. The defendant's position seems to be clearly no. Basically, the voter should be grateful they got one chance to vote, and they'll get one again down the road. My position is when an elected office is being occupied by someone who wasn't elected, that's a constitutional issue under both the federal and state constitutions. Yes, Your Honor.
Mr. Leiden, we had not a very similar issue, but a somewhat similar issue in a case involving Fairfield, where the charter laid out a specific way for the voters to elect a person. In that case, we turned to the charter because there was home rule in Fairfield, the town of Fairfield. What do you say to that?
That's the Cook-Littman case, Your Honor. And in that case, there were no constitutional issues raised. And I went to look at the briefing to be sure of that, and literally nothing was stated about the Constitution at all. Nor was there any issue about changing the rules while the election is underway, nor any issue about waiver by the people who are contesting it, not bringing the matter to court. So none of those issues took place in Cook-Littman. All it was I would characterize as a fairly routine application of the charter. Clearly, if the charter is in conflict with the Constitution of the state of Connecticut or the United States, the charter must yield. and that, again, I think is kind of the linchpin of this. The defendants just say, charter says biennial means odd, end of analysis. And to me, that's the beginning of the analysis.
What is the constitutional violation?
It is depriving the citizens of their right to elected representation, which goes to the heart of a representation.
Citizens voted on the charter.
That is true, I believe, under the Connecticut. Yeah, that does get true under Stanford. But that does not mean that the citizens said that we delegate, that we don't get to choose who's our elected representatives.
No, it does, doesn't it? When you say that we are voting for a biennial election cycle, then they've decided that they will pick the people who they choose to elect on the various boards pursuant to that procedure.
I disagree, and that's what goes into the what I'd call the sort of statutory or charter construction issue, where the defendants say biennial means odd, period. And I disagree with that construction. And then you have to look into what did they mean when they said biennial when that was written back in 1949.
Is biennial ambiguous?
Yes, it is. If they had said odd, that would remove all doubt. Biennial, in my opinion, meant the next town election. It also, at that time, meant odd years. So the question is, was the essence of the thing being done there an odd year? Were they numerologists for whom odd was really important? Or was it the next town election, the essence of what they were seeking to convey? I would suggest the latter. It was the next town election. And then when that split in 1969 and there were town elections from Board of Ed, which carries more weight? Did it be the next town election or that it be an odd number? And again, I think the next town election is what was more important there, not that it be an odd number, particularly when you take into account that people are being deprived of elected representation. And I don't think there's that can simply be delegated away by an obscure interpretation of the charter, inconsistent with the elected officials' interpretation in 2016 and again in 2020 for the most part.
I see there are other questions, Mr. Lydon. So if you're finished answering my question, then I'll move on to the other justices.
Sure.
I'm always getting the order wrong on this. Is it Justice Storia is first?
I might have been. I'll jump in here. I see where you're going with this, Attorney Lydon. I mean, you're trying to argue your way into constitutional jeopardy, and I think you need to be. I'm going to ask you to be very precise about what the constitutional problem is with these couple of scenarios. Let's say the charter was crystal clear that there was if there's a vacancy the day after somebody takes office, then the Board of Representatives elects somebody and they serve the rest of the 3 years. Constitutional problem?
I think so. I mean, it's obviously less clear than here, but I think so.
Under what? Under what exactly?
Because I think the principle that the people should be electing their representation is more important than just what the charter says. If and this is to round it out. If there's an election coming up where it's easily placed on the ballot and there is no hardship or burden whatsoever to conducting that election.
That seems a policy question as to whether I might agree with you that that's the best way it should be handled. But I mean, you're aware, or at least I was aware at one point, it may have changed, but there are boards of education where I think New Haven is not elected at all. That's by statute, that they're all appointed by their governing body. Is that unconstitutional?
No, if it's not an elected office. I think where the Constitution
that kind of begs the question. That begs the question is you know, you're suggesting that there's some sort of a constitutional right or constitutional infirmity, and the cases say there needs to be a serious constitutional question to get the benefit of a constitutional jeopardy maxim. If there's no constitutional right in the charter to an elected representation, say after, you know, anytime there's a vacancy, that's what the charter says. I guess I'd need to see a case that you're citing that direct representation, direct election somehow is a fundamental right for offices that the charter or the statutes can qualify.
And I know there's a U.S. Supreme Court case, the name is escaping me at the moment, but it had to do with electing Board of Education. And in that case, the rule said only people with kids in school could vote for the Board of Education, and the U.S. Supreme Court said no. Now that was in the charter or the statute that applied to that says that. So the people enacted a charter that said only people with kids in school can vote in the Board of Education. So that would meet your hypothetical. And the U.S. Supreme Court said you still can't do that. Once it's an elected office, that gets then all the rights of an elected office that needs to be treated very seriously by the constitutional that starts with we the people. It's sort of a starting point. Once it's an elected office, I think these rights come into play. If you're talking about an appointed position that never was an elected office, then it doesn't. But I think that's a pretty easy distinction. If under that system it's not deemed an elected office, then obviously that's not an issue.
Okay, thank you.
But this clearly is an elected office, and again goes to my point also is, and there's cases I know I've seen where, for instance, there was a claim that a special election had to be called as opposed to waiting for November, and the courts have more or less said, no, you can't necessarily insist on that because there's countervailing considerations, because there's an administrative burden on doing that, because the electorate's different in a special election. So those types of concerns could outweigh the need for the people to elect their representatives in a certain situation. But here where you have an election day, where you have it on the ballot, where there's no burden whatsoever to doing that, and to date, a rational basis has yet to be proffered by the defendants. I'm looking forward to it. Maybe we'll get it in their argument. but not even a rational basis or a legitimate government interest, let alone an important one for intermediate review or a compelling one for strict scrutiny. They just say the law is what it is, and that's it. That the law says that can never be a sufficient rational basis as a mere tautology, because then obviously no law could fail that test. So that can't be it. And when it's so easy to have it on the ballot, so easy, in fact, that it was done, then the constitutional implications of both the First and 14th Amendment federally and a half a dozen state constitutional concerns outweigh not having it on the ballot. And I haven't even gotten to the fact of changing the rules once the election is underway, which is even worse in this case. The election was underway, ballots had been returned, and then there's this new construction saying, sorry, maybe next time. The rules are really clear that once the election is underway, it takes a compelling interest to say, no, we're going to change the rules now. We're going to deprive these people of the election after it started, based upon a new construction of an established past practice of when this should be on the ballot, which is another important consideration. And the defendants on that say there's no real established past practice. It was just once in 2016, and that was a fluke. That's not true. It was the people charged with enforcing that charter provision had numerous steps, each of which constitute a ruling of an election official that can be appealed under 9328 that was not appealed. Both in 2016 and again in 2020. So those officials interpret it that way, I believe properly so. I believe there's a question.
I understand. I'm just making sure that you finished answering.
Yeah, I was finished. Yes, sir.
Justice Daria, are you satisfied with that answer? Justice Khan?
Yes, all set.
Thank you. Thank you, Chief. Counsel, I have questions. My questions were along the lines of Justice Doria's question. The example you used, the Supreme Court case example you used, sounds like the charter was allowing only a group of people to vote, and in essence discriminating against a different group. And that's not the case here. I noticed that in your brief you don't address the Cook-Littman case that this court heard at all. You address it briefly in your reply brief. I know in answer to the Chief's question, you said, well, that case is different. They didn't raise constitutional claims. But as I recall, I was on the bench then, the issue was the same. Who gets to decide who fills a vacancy? Is it decided by the charter, or is it decided by a vote in the next election? The issue wasn't when that election would occur, but the issue was which one, rules. Is it the charter, or is the vacancy filled in the next election? You raise a constitutional argument. I'm not sure I quite understand what constitutional provision you claim is being violated. But even assuming so, are you saying that the Constitution, both the state and the federal Constitution, only allow one way to fill a vacancy, and that there's only one constitutional way to fill a vacancy and no other way is acceptable?
What I would say is when election day comes and that office or class of office is on the ballot, so if there's no administrative burden whatsoever, then yes, then the people's right to choose their election has to trump some other type of convenience argument.
What part of the U.S. Constitution, federal Constitution, or the state Constitution provides for that, for the proposition you just stated?
For the federal, I would say the 1st and 14th, which have been construed repeatedly to allow a fundamental right to vote. I would even go as far as to say the first 3 words of the Constitution, "we the people," implies it pretty strongly as well. That's a foundational right. And then in the state Constitution, I've articulated it's Article 1, Section 2, 4, 5, 8, 14, and 20. There's not one provision that says vacancy elections must be held at the next convenient election. I'm not claiming that there is, but there's a slew of sister state cases that say precisely that. as a foundational principle.
So if the people, we the people of Stamford, and I'm not including myself in that, I'm just borrowing your words, we the people of Stamford vote for a charter that calls for the filling of a vacancy in a certain way, how does that not satisfy the constitutional provisions you're referring to? And that will be my last question. And then if I see my colleagues have their hands up. So that's my last question. How does, it really relates to the questions the chief was asking you, and that were decided in Cook v. Littman. How does the fact that the people of Stamford vote for a charter, so we the people voted for a charter that calls for the filling of vacancy this way, how is that contrary to the Constitution?
I would say I don't think you can really claim that the citizens of Stamford understood in enacting that charter that vacancy for Board of Ed meant that it's only odd year, because that's how biennial was going to be construed by a later person, despite it previously being construed otherwise. So I think it's something of a stretch to say that's what they chose. Two, though, I think there's a more compelling principle that people should be able to elect their representatives, and I don't think it can just be deferred or sort of given off to somebody else without a reason, without at least a rational basis. And I would suggest more likely intermediate scrutiny in a case where you're not changing it while the election is underway would be applicable. Here's the reason why that makes sense. We can't hold them in even years because of X. If they said that and what they said made sense, I'd have a much harder problem. When they just say by no means odd, that's that, I will give you no reason, then yes, it's an arbitrary and capricious rule, and you're not allowed to enact arbitrary and capricious rules, even if you do so willingly.
You're basically saying the charter saying so is not enough. I understand your argument. Thank you for answering my questions. I will refer back to the chief.
If I could just follow up on that, because I do think it's important because of what's been said about Cook-Littman. It can't possibly be the case that Cook-Littman controls a constitutional issue being raised by here when literally there was no constitutional issue raised in that case. So one can claim it relates to the statutory construction issue. I have differing arguments on that, but it can't possibly answer the constitutional questions.
Thank you, Mr. Lydon. Senior Associate Justice McDonald.
Thank you, Chief. Counsel, I think I have two questions, maybe with a couple of subparts. So in your brief, you say that a biennial election is the next town election. Town election in contradistinction to what?
For instance, I could see a situation where on even years, if there are no municipal things on the ballot and it's only, say, state reps, and there are different districts and books, so it'd be inconvenient to hold that election then, there might be a reason not to have it then. But when that office is on the ballot, a town election office for Board of Ed, which they did have here, then there's no reason not to have it.
Well, you point out that Board of Education races are on the ballot every year. So correct. In your view, even in even number of years, it's not a state election. Even if we're electing a governor, all state representatives, state senators, U.S. senators, congressmen, that's not a state election in your view.
I guess where I would disagree is I don't think those are mutually exclusive. It's not either or. If there is a town office on the ballot, it is a town election. It can also be a presidential election. It can also be a state election, but it will be a town election when a town office is on the ballot of that class.
Okay, my second question, and you obviously are aware that I have some familiarity with how Stamford comprises its government. You asked for a difficult question that would make this irrational. In that provision of the charter, C-182 subsection C that we are talking about, it also talks about special elections for, among other things, the Board of Representatives, right?
Yes.
And you will agree with me that the Board of Representatives is comprised of 20 districts in the city, correct?
Yes.
But in state elections and even numbered elections, there are 23 districts, not 20. Is that correct?
I'll take your word on that. That sounds right.
They are not coterminous districts, right? The lines are completely different. So if there was a vacancy in the Board of Representatives, and that vacancy had to be filled at the next biennial election, how could it be done in an even number year when the district wouldn't line up with the people who are represented in that district?
That would go to my point was, so when someone said, what's your rational basis for that? The answer would be what you just said. so it could pass constitutional muster because there'd be a reason for not doing so. We've yet to hear that reason here.
Okay, but the problem I'm having then is if you concede that a Board of Representatives vacancy would have to be filled in an odd numbered year, because of the way districts are aligned, then you're attributing two meanings to the term biennial election, depending on the office that it is applicable to, correct?
It could be, and it goes back to my point that what was the import of what they were conveying? Was it numerology, or was it the next town election where that office can conveniently be voted on? So that's the point.
So in some instances, you would have to argue, I guess, that for a Board of Education seat, the next biennial election would be 2020. But if it was a Board of Representatives seat, the next biennial election would be 2021.
On the Board of Reps issue, like I said, it would depend on, because I realize what you said about the districts, but it just struck me as if the Board of Ed is also on the ballot, you'd still have municipal districts that might line up the same as the Board of Reps. I don't know that off the top of my head. The
difference is that a Board of Education seat is a citywide office as opposed to a district-based seat, right?
So it could be, we're sort of like two steps away from this case. So I'm kind of thinking on the fly here. Like I said, my point would be if there's and I think it'd be intermediary if it's not changing Dermot. So if there's a important governmental interest, and this is narrowly tailored to meet that interest, then yes, that would apply. But like, assuming you're not changing it when the election is underway, which to me is a different question. There, I think you need to meet strict scrutiny. But if someone brought that challenge beforehand and you were construing it ahead of time, and you said, here's the important governmental interest, we can't do it administratively, presumably you'd have some record before you that shows why that's a problem, then that probably would pass, I think. But when there's no reason not to, when it's on the ballot, when it's already there, and it's very convenient to take place, then no.
Thank you.
Justice Ecker?
I think I have two questions or two sets of questions. One is a simple factual point, and perhaps I should know the answer, but I don't. Were there votes cast in this election prior to October 16th?
Yes, and it's Exhibit 3. It's an affidavit from an Eric Rhoda, who, interesting in our modern era, posted on Instagram on October 8th.
I saw that. That was prior to October 16th.
Yes, it was.
Okay. Were voters ever notified of the Corporation Council's decision, or in a formal way, in a newspaper notice or otherwise? Do you know?
Definitely not in any formal way. There may have been newspaper articles, but not, say, a legal notice, which is deemed of legal significance. So right. There was
my other set of questions, or it may be one, it may be more, is just about the charter provision. I mean, certainly in the abstract, biennial election strikes me as pretty unambiguous, and annual election strikes me as pretty unambiguous. I take it your argument, and help me here. Your argument, apart from the constitutional assistance that you're trying to Garner, is that in 1951, at the time, there were only biennial elections in the city. Is that what your argument is? There and annual elections only were introduced later in at least for the Board of Education in '69.
Correct.
And so is your argument really, look, this was sort of an oversight? They never went back and changed it?
I think so. I think, quite frankly, that's fairly clear. And like I said, I think that's where I say what was the import or the essence of what they were trying to do? And I say when there was a next convenient election for that very office or class of offices, as opposed to the numerology of odd.
And I don't have command over the Stanford Charter the way other participants in this conversation do. So bear with me. Are there any other places in the charter, in the Stanford Charter, where the changes were made to distinguish between annual elections and biennial elections? I mean, other than are there? Was this a global oversight, or was it just, in your mind, a selective single oversight?
I believe selective. I don't think there's others where there was any particular change made or not made.
Okay, thank you.
Your time is up, but Justice Kelly, you have a question?
Chief, if I could, I think that the defendants could answer my questions just as readily. So if I could just be allowed to ask them the first questions, that I would appreciate that. Thank you.
Okay, thank you. Appellee, you're ready to proceed. I don't see Mr. Bear at all on my.
He might be muted.
He's
My
muted.
apologies.
He's
I was
on.
muted. Let me start again. Aaron Bear on behalf of the Stanford defendants, Your Honors. Really, there's one dispositive issue in this appeal, and we think it takes care of all of the plaintiff's arguments, which is, what does the charter say and mean? And in this case, there isn't an ambiguity. There is a single provision in the Stanford Charter for filling vacancies in any elective office. If you look at the provision C1-80-2, which is on page 93 of the appellant's appendix, it's very clear. The first subsection says, if an elective officer resigns, there's a vacancy. The second provision, B, says, if there is a vacancy in any elective office, it is to be elected, a successor is elected by the Board of Representatives to fill that position until December 1st after the next biennial election. We maintain that there's not an ambiguity about that. It says biennial. It has a responsibility that the citizens of Stanford have put on the Board of Representatives to fill the vacancy in the interim. And the term of that filled vacancy is very clear. If there were any doubt, subsection C clarifies it, because it says, then if the Board of Representatives has filled the vacancy, there must be a vacancy election at the next biennial election. And subsection C specifically applies to the Board of Education on its face. So there isn't an ambiguity about whether there should be a different provision for the Board of Education. And just to follow that thought through, Your Honors, if you look at C180-5, which is the section that was adopted in 1969 to have 1/3 of the Board of Ed elected each year. And the argument that the plaintiff has made here is that perhaps there was an oversight, and the drafters of that provision intended to create a separate process for filling Board of Education vacancies, and that those could happen every year as opposed to biennially for the rest of the offices in Stanford. But if you look at C1-80-5 on page 94 of the appendix, the very first clause in that provision is, except as otherwise provided in section C1-80-2 as to the filling of a vacancy. So the drafters not only didn't overlook that there was already a process in place for filling a vacancy on the Board of Education. It specifically incorporates and cross-references it in 1969 when it adopts annual elections for 1/3 of the Board of Ed. So there really can't be an argument that somehow the drafters of the Stamford Charter missed something, or that they intended to create a new and different process for filling a vacancy for the Board of Ed. They did not, and it's not, and really under home rule, that's a decision that the people of Stamford make when they adopt the charter.
Attorney Baird, there are a number of different questions. We'll start with Justice Keller.
Thank you, Chief. Good morning, Attorney Bayer.
Good morning.
I have just 2 questions. If someone vacated a Board of Ed seat in a biennial year, the day before the biennial election, what would occur?
So the answer is I'm not 100% certain, but there are, if you might have to fall back on statutory provisions which state that there are certain time limits for a candidate to be put up for election, so that the election process can proceed. I don't remember off the top of my head what those timeframes are, but if it's the day before the biennial election, there really isn't an opportunity to run. So I think what would happen—
So you go to the next biennial election would be the election.
Correct.
And that person would fill the vacancy for almost 2 years, right?
Yes, unless their term expired.
Yeah, and then they would run, then it would, right.
And then it would become
for any party candidates, Republican or Democrat, endorsed for this seat, this vacancy?
In 2020, Your Honor?
Yes.
So what happens in 2020 is initially the Republicans tell the town clerk they want to put a candidate up for the 1-year vacancy. Now that vacancy has already been filled by the Board of Representatives, but they say they want to put someone up for election. But eventually they withdraw that candidate, so there's no candidate running.
Right,
and
because the plaintiff talks about depriving citizens of their right to elected representation, but the major parties and the people who ran for their regular seats got somewhere in the area of 34,000 votes apiece, correct?
Correct.
All right, so the regular parties didn't bother to endorse anybody. And all of the members of those parties in Stamford didn't get their right to elected representation in a way because they weren't allowed to endorse and they weren't allowed to put anybody on the ballot, correct?
Well, that's correct, Your Honor, but I just want to make my position clear. Had one of the parties endorsed a candidate for this 1-year Board of Education position, as a matter of law, it wouldn't make a difference because the touchstone is whether there could be a vacancy election for that position under the terms of the charter. And the answer to that is there could not. The charter has a specified process. The Board of Representatives had filled that position to last until the next biennial election. So there wasn't a vacant position to put on the ballot. It was done in mistake by the town clerk.
But I guess what I'm saying in balancing it, if this person was allowed to be seated with 500 votes, is that really constitutional when an election was held without giving the normal party process a chance to endorse candidates and all the people in the town a chance to pick a full slate of candidates?
Well, I don't know whether, I'm sorry?
Go ahead. Go ahead.
I don't know whether it implicates a constitutional issue. It does implicate the charter because the charter wouldn't have allowed for it. Right. But to take your point, there are multiple parties that have interests in the process being followed as the charter is written. I mean, the people of Stamford, when they adopt and endorse a process for filling vacancies for all elective offices, including the Board of Ed, they have a right to have their elected representatives follow that process. And if plaintiff were correct, you would be displacing Rebecca Hammond, who was lawfully put into that position and to remain in that position until the next biennial election, and her rights would be implicated. And those are rights that she has under the charter as well. And what Cook-Littman says, because Cook-Littman really is quite parallel, in that case, there was a vacancy in the Board of Representatives, the Board of Selectmen in Fairfield. The Board of Selectmen, pursuant to the charter, appoints someone to fill that seat A group of electors seek a special election under state law. They get it. There is a special election and someone else is actually elected. And what Cook-Littman says is it does not matter. The election wasn't lawful. The charter provided for appointment of a person to that seat. And therefore the election is unlawful, and that person who was elected has to be removed, and the original person who was appointed has to be put back in. So had this actually gone forward, had the city not seen the mistake, had not endeavored to correct it and corrected it, what we would be arguing here is that Ms. O'Shea must be removed from the seat and Ms. Hammond must be put back in under the law under Cook-Littman. Fortunately, we didn't get to that point because the town clerk sought legal advice once a question was raised about whether the ballot was erroneous and shouldn't have had a blank column for this one-year Board of Education. She got that advice from the Corporation Council. The Corporation Council issued her opinion. The city, in an effort to be as fair and transparent as possible, on October 16th, the mayor called a meeting, a Zoom meeting, with the town's elected officials and Ms. O'Shea and the other candidates for Board of Ed seats, and told them what they had found, told them that what went wrong, and told them that there could not be a lawful election this year for that seat. There couldn't be a vacancy election. The city was in touch with the Secretary of State's office to say, under these circumstances, we have concluded that there cannot be an election. And the Secretary agrees with the city that it would be more disruptive and disenfranchising to require them to issue a new ballot. And the Secretary ultimately agrees that it's up to the city to interpret its charter. But if the city has concluded that that position is not lawfully up for election this year, the Secretary does not expect the city to be reporting certified results of that election that could not lawfully take place. And the city understands that and meets with the candidates again and the elected officials again to reinforce what happened and make it clear that there could be no lawful election and the city cannot report certified results to the Secretary and will not do that. Just in response to a question that Justice Ecker, I believe, asked, when the Corporation Council issued her opinion on October 16th, the town clerk immediately posted it on the city website. And it was brought up specifically in the second meeting with the candidates and the town officials on October 21st, and the opinion was discussed, so everyone knew about it. Before I go on, does that answer your question sufficiently?
Thank you, Attorney Bear. There is another question from Senior Associate Justice McDonald.
Thank you, Chief. Attorney Bear, I guess I think my question is sort of process driven, and I will address it to you, but I intend to also address it with Attorney Osborne. If we disagreed with your position, who, under these facts as they currently stand, who would be elected to that position?
If you disagree with us.
Correct.
Well, Your Honor, that gets to a much more complicated question of remedy, which the city has not taken a position on in this case.
Now, it gets to a different question, actually. I find it very troublesome that the head moderator had before him hundreds of ballots cast for individuals that were counted preliminarily and then were zeroed out on the certified returns. It was an inaccurate report of the vote. It may not, they may have not been voting for a position that was legally available, but that doesn't mean that their votes were not cast. And I'd like to understand what the authority is that permitted the head moderator to negate the hundreds of votes that were actually cast.
So, Your Honor, let me address that as best I can. There were limited alternatives available because of the mistake that was made, Your Honor. But there isn't an option.
I'm sorry to interrupt, Counsel, but the problem I have with that is where you begin dictates where you end. I understand your position that it was improperly on the ballot, but that is a legal conclusion that ultimately a court has to make. I understand the Corporation Counsel did her best to provide guidance, but it is not a definitive statement of the law that is controlling on the parties. And so in the absence of controlling authority, what permits the head moderator to negate votes that were legally cast?
So, Your Honor, I think there's perhaps something of a philosophical disagreement here. I don't think the moderator negates the votes that cast. I think the condition precedent for votes is that there is a lawful position that they can vote for. If there isn't, those votes can't be tabulated, and the system
that assumes the conclusion.
Correct. I apologize. So the question you're asking me is, even though votes were if the votes were cast, should they have been reported to the Secretary of State? So my understanding, and it is a good question for Attorney Osborne, but my understanding is there isn't really an option under the Secretary of State's system for saying, here are the votes that were cast. The city had no authority to put this on the ballot. There is no lawful election. So here are the votes, but they're not to be counted in terms of who wins and who has a right to the office. It is a mechanical system that you can put in a number only. It is a computerized system. You put in a number and that's it. And the secretary takes those numbers and certifies from them that that person has won the election, is entitled to hold the office. So when the secretary says to the Stamford election officials and the Corporation Counsel, when they have their email conversations about this, what the Secretary's office says is, it's up to you to decide what your charter means and whether you have authority to hold an election for that position. You've concluded that you don't, and that's fine. We don't question your authority to interpret your own charter and act in accordance with it. But if that's the case, we are not expecting you to report results from that election. Ordinarily, this wouldn't happen, Your Honor, because if it happened earlier in the process, if there weren't a pandemic and people weren't voting and by absentee ballot en masse and returning them early, what would ordinarily happen is the secretary would have asked the town to print a new ballot, and you just would have had a clean ballot, and the election would have proceeded that way without the blank line on the ballot, and there wouldn't have been this problem. But in this circumstance, the secretary and the city were faced with, what do we do now that this has happened? And the most effective thing was what they did.
Why wouldn't the more proper manner of proceeding been to actually report the truth about the number of votes cast, have them certified to the Secretary of State, and then the city, having created this problem, would bring a declaratory judgment action to declare that there was no legal position to be filled, and therefore there was no person elected to the position? Why wouldn't that have been the more proper procedure under this scenario?
You know, Your Honor, I guess that is an alternative process, but it seems to me that necessitating a lawsuit after the fact and sanctioning as valid votes that were cast for a position that wasn't available for election is kind of distorting what Stamford officials are empowered to do. The Stamford officials can only do what the charter permits them to do. They only have the authority the charter gives them. So I think under these circumstances, when the city officials recognize that a mistake had made, recognize that there was no vacancy to be filled, it had already lawfully been filled and couldn't be filled in this election, they did the right thing. They issued an opinion, they informed all the participants so everybody was new, and they informed the Secretary of State and got what guidance they could from the Secretary of State.
And I appreciate that. And I understand the unique circumstances here. I will ask Attorney Osborne this because you know, the notion that a head moderator can adjust tallies of votes because he believes that they were improperly cast without going through a formal legal process, especially in the environment in which we live right now, is an extraordinarily disturbing concept. That the truth of what was done at the polls doesn't need to be reported. But I accept your position and your answer, and I'll reserve the balance of my questions for Attorney Osborne.
Thank you, Your Honor. With respect, I think there might be a difference between a determination by the moderator that votes were not properly cast as opposed to a determination by the moderator and the other city officials that there was no seat to be, for those votes could be cast for. I mean, I see that as a distinction. Addressing some of the other points that opposing counsel raised, as to the constitutional question, the predicate, it seems to me, for a fundamental right to vote is there has to be an office to vote for. If there isn't a proper election, if there isn't a valid election for a particular position, the fact that votes are cast or not cast doesn't implicate a constitutional issue. There's a condition precedent for the fundamental right to vote that there has to be an office that you could lawfully cast a vote for. As to the question that repeatedly stated that there's no rational basis for the city to have the methodology it has chosen for filling vacancies, Justice McDonald gave.
Attorney Bear, Justice Doria has a question.
Thank you. I want to take you through a couple of the points that Attorney Lydon makes about how, before we got to this point, 2016, an election was held for a vacancy. The world didn't come to an end. I assume somebody served in that position. And then the election was underway, is his point, in 2020, which I think is not unusual. I mean, it may be unusual this year in the number of people that voted, but military ballots, absentees go out all the time. So, and that's going to become our world more and more. Was any thought given to the idea of letting this election go forward and applying this prospectively? I mean, it's hardly unusual that something comes up and we, you know, I don't take Mr. Lydon's point to be really in his favor because I mean, we litigate things all the time that somebody's done something before and now somebody challenges it. But could equity, if this were a quo warranto action, are you saying that there's no way a court could ever consider, you know, this is a fair construction, yes, maybe the right construction, but we've had an election?
So the answer, Your Honor, is no. And I think and that answer comes from your court. This court in DeMayo and Cook-Littman are very clear. City officials have only the authority given to them by the charter, and in particular, where the charter specifies a method for appointing an official or electing an official, it must be strictly followed. And there isn't discretion to do something else, to let the election go forward and then fix it some other time. They only have that authority. That's the first point. The second point is the notion that the 2016 mistaken election somehow constitutes an established past practice that should dictate how the charter should be construed makes no sense. It was
I'm not suggesting that. I'm suggesting that it doesn't do great violence to the electorate per se. I mean, nobody's challenging that I know of that any of the actions taken by the Board of Ed were invalid. And sometimes you get where, you know, you are where you are. And, you know, if this had happened post-election, and I'm not suggesting the city, you know, the city has to interpret its charter the way it has to, but are you saying a court couldn't say, look, you know, we are where we are and there's been votes cast and that may be the right construction, but, you know, you're going to disenfranchise somebody is the point.
So I think the answer to that, Your Honor, lies in home rule and the city's charter, because what if the city can just, the city didn't wait till after the election. I think it's fortunate that they didn't, but even after an election, as in Cook-Littman, there was a special election. And it wasn't just a few write-in votes. There was a special election pursuant to state statute. The citizens voted and a different person won. And this court says it doesn't matter. It doesn't matter. That was an invalid election. If you must strictly follow the process for electing or appointing an official. And if not, it's an unlawful election and that person has to be removed and the person properly put into that position must be put back in. So I think the answer is if it was recognized after the election and there was a lawsuit, then and we had done what you suggest, the city had done what you suggest, Ms. O'Shea would have to be removed under the precedent of Cook-Littman. And I think that flows from the concept of home rule and allowing cities to set up their own processes, and then they're expected to follow them. And Your Honor, I don't think, I mean, you're right. There isn't an easy way when you're in the middle of this to find something that hurts nobody. I just happen to think Stamford did the best it could to address the situation, inform everybody, coordinate with the Secretary of State, and then follow its charter once it realized that it couldn't hold the election that the ballot on this ballot. And you know, Your Honor, I think if I've answered your question, I'll just move on.
Yeah.
I did want to follow up on Justice McDonald's point about whether there is a rational basis for the process that the city has adopted. If the city adopts it, it is perfectly rational that they should be expected to follow it. But B, there is nothing irrational about the idea of the city wanting to have a single process for filling vacancies. It makes sense. It's simpler. It's easier. And you don't need much for a rational basis under the Constitution.
But Counsel, I think Attorney Leiden's point would be, and I don't mean to speak for him, but I think his point would be that no rational basis was given. So the decision was not made on a rational basis kind of standard. It was made on a arbitrary and capricious standard.
Well, I guess I'm confused because if Your Honor is saying that there was the rational basis test has to do with the constitutionality of the statutory provision, or in this case, the charter's provision, and the rational basis test is whether the drafters, whether the adopters of that statute or charter provision could have had a rational basis for adopting it. It's not whether in this case following it was rational, it's whether the statute was rationally adopted. I suggest that there are multiple reasons to say it's rational to have a single process for filling vacancies. And in particular, as Justice McDonald said, it would be more complicated in a way to have some vacancy elections held on the even years and some on the odd years, and that's not what they did.
Okay, I'll have to wait and hear from Attorney Leiden to see what his position actually.
But did I answer your question sufficiently, Your Honor?
You did. Thank you.
So I don't think so. I think there is certainly a rational basis for the process the city adopted. I don't think there's any basis for concluding that an isolated instance in 2016 constitutes an established past practice. I would just say in this regard that in DeMayo versus Quinn, which had to do with the city's city council having appointed a corporation council, but not in accordance with the charter. The charter required that the city council appoint on the recommendation of the mayor. They didn't do that. One of the arguments the plaintiff made in that case was there was a 20-year history of both the city council and the mayor interpreting the charter to allow the city council on its own to appoint the corporation council. And what this court says is that doesn't matter. You must follow what's in the charter, and it doesn't matter that the city interpreted it differently for 20 years. It's still, the charter is what the charter is, and that's what motivates and animates the court in Cook-Littman. The other thing I was going to bring to the court's attention is this.
One second. Unfortunately, I had my list scrolled down. There's two justices who have questions. I couldn't see the virtual hands.
My apologies.
No, it's my fault. Justice McDonald and Justice Kahn.
I'll be quick. Counsel, you talked about, both parties have talked about a 2016 precedent. I don't live in Stamford anymore, but I did for a long period of time. I recall a number of one-year special elections for the Board of Education. Has there been a review of a long history of elections, and it's been determined that this is the only one that would have fallen in a state election for a special election?
For the Board of Ed, you mean?
Yes.
The answer is I don't know. There's nothing in the record of this case. This is a very limited record, both on a set of stipulated facts. Thank you, Your Honor. A set of stipulated facts and agreed upon exhibits. The plaintiff did not put on any witnesses other than the Corporation Council, so there was no examination of that issue. I mean, I looked back back to, I think, 2012, and there were none of those elections in 12, 14, and 18, but it's not in the record. It was the burden of the plaintiff to look at that, but I'm unaware of other instances besides 2016.
Thank you.
Justice Kahn, then Justice Keller.
Thank you, Chief. Attorney Baer, I have two questions, so let me just, the first one is very simple, and so I'll just tell you both questions. The first question is, as I understand it, the charter has been amended by vote of the people of Stamford a number of times, correct?
Yes.
Okay. And my second question is, your opponent, Attorney Layden, in his reply brief, tries to distinguish Cook-Littman. He's not asking this court to overturn Cook-Littman. He thinks it's distinguishable from this case. My question to you is, if we were to agree with Attorney Layden, would we have to either expressly or implicitly overrule Cook-Littman?
I think to adopt the position that the plaintiff is advocating here, you would not only have to overrule Cook-Littman and overrule DeMayo versus Quinn. I think you're essentially overruling a legacy of home rule decisions by this court that make it clear that you cannot, that a city's charter as to matters of local concern, which includes how local elected officials are elected, how vacancies are filled. These are clearly matters of local concern. The charter is what controls, and the court can't rewrite the charter, put in a special vacancy, process. Thank you. Put in a special vacancy process that isn't there. So I think it would be a very fundamental shift. As to the distinction in Cook-Littman, I would just like to make clear that in Cook-Littman, one of the arguments that was made, and I'm quoting from the case, was that if you construed the charter and statute the way the court was construing it, it would be anti-democratic and disenfranchise the town's electors. That is to say, if you did not honor the special election and instead enforce the appointment by the Board of Selectmen, it would be anti-democratic and disenfranchise the town electors. And the court says the electors have not been deprived of their opportunity to participate in the democratic process with respect to filling a vacancy because charters are adopted and amended at referendum by the city's electors. And therefore, if the charter is to be altered, the town and not this court must be the forum for any such amendment or revision.
Thank you, Attorney Baer. I know that the chief also called on Justice Keller. I want to give my colleagues a chance. Thank you.
Thank you, Justice Kahn. Justice Keller?
Thank you, Chief Justice. Attorney Baer, I want to ask you about General Statute Section 9256 that you cite as addressing what the Secretary of State does when there's a mistake on the ballot. And it gives her an option of requiring the town to issue a corrected ballot, which I understand was discussed, and because of the uniqueness of this particular election with all of the COVID-19 absentee ballots that had already been sent out, they decided that would cause more problems than it would solve, correct?
That's right, Your Honor.
All right. So in addition, she has the authority to take any other action she deems appropriate. Is that correct?
That's what the statute says.
So specifically, she told the town, just don't count those votes, right?
I think she agreed with.
Tell?
I think the more accurate way of stating it, I don't want to put words in the office of the Secretary of State, but when I read the emails, the town requests of the Secretary of State that they not be ordered to reprint the ballot at that late date, and that they be allowed to have the election go forward. Because it would otherwise be too disruptive. And the Secretary's answer is, they had the discretion to do that. They did not require the town to issue a new ballot. And then the follow-up was, since you have concluded that this is not a seat that is lawfully up for election, we do not expect you to return results. Meaning they don't want to end up with the Secretary's office getting certified votes for an election that shouldn't count.
And if the town had certified them, following along on Justice McDonald's questions, would there possibly have been some municipal estoppel occurring at that point?
I don't think so, Your Honor. If we had been, I think that if the town had been required to certify those votes by the secretary. The votes would have gone in and there would have been a lawsuit after the fact, as I think Justice McDonald suggested. And presumably that lawsuit would have been filed by Ms. Hammond, who would say that was not a lawful election. The town had no authority to put that seat up for election. I am in that seat pursuant to the lawful process under the charter that with the Board of Representatives having put me in place until the next biennial election, and it would have been an action to remove Ms. O'Shea from the seat. And quite honestly, under Cook-Littman and DeMayo and other precedents, that's exactly what would have happened. It would have been the same legal issue under the charter that you're facing today. It's just structurally it would have be taking place in a different context.
All right, thank you.
Anything further, Attorney Bear?
No, Your Honor, I think in sum, I would just say I think at the end of the day, what the plaintiff is asking this court to do is revise the charter, and it does not have authority to do that and shouldn't do that. And I thank the court for its time.
Thank you very much. Before we hear from Attorney Lydon, I believe it's Attorney Doss and I'm sorry for pronouncing the name wrong, Esses?
Yeah, Esses is right. Thank you.
Good morning, Your Honors, and may it please the court, Prolay K. Doss on behalf of Rebecca Hammond. Your Honors, our position is that Ms. Hammond is a valuable member of the Board of Education and a properly elected member of the Board of Education. She is and should remain a member of the Board of Education regardless of the outcome of this litigation. If the plaintiff is correct that there should have been a vacancy election in 2020, then Ms. Hammond would hold a 3-year seat. If the city defendants are correct that there should not have been a vacancy election in 2020, then Ms. Hammond would hold the 1-year seat. Now, what the plaintiff is asking for is this court to issue an illegal result. She's asking not only to be instated onto the board, but to replace Ms. Hammond, who is one of only 3 Republican members of the Board of Education. And, Your Honor, I see that there is a virtual hand up.
I believe Justice Keller's hand is up from last time. So please continue.
Thank you, Your Honor. The result that the plaintiff is seeking is barred as a matter of law by the minority representation statute. The minority representation statute talks about how a situation when you have, and I see Justice Diori has a question, Mr. Chief Justice.
Thank you, Attorney Doss. Justice Doria.
Yeah, doesn't the plaintiff make a good point? I mean, why would we get into all of that? The court counsel could probably fuss that all out, make a ruling on who should hold the seat.
Your Honor, I think our point is that if you do get to remedy, it would go back to the trial court, because under both 9328 as well as 5229, the trial court is the one who would issue the order in the first instance and could not do so without affecting the rights of one of the 3 candidates in the regular election, meaning the lowest polling Democratic candidate. So in that situation, because under 9328, any candidate that's going to be affected by the result has to have notice and opportunity to be heard. If this court were to agree with the plaintiff on the merits, it should be remanded back to the trial court so that notice could be provided by the other affected candidates.
Okay, so you're not asking us to, if we rule for Mr. Lydon's client to rule that your client gets the 3-year term. I mean, that's not really before us. I mean, I'm not sure. You represent her in her official capacity, right? I don't know what that means exactly, but I don't know how that issue would be an official capacity question.
Yeah, I guess the question is, who would necessarily hold the seat, and would, Ms. Hammond, who is an official capacity Board of Education member, continue to be an official capacity member of the Board of Education? But I think that's something the trial court would have to address, and that's why we're addressing, if this court were to reach remedy, it needs to go back to the trial court. And I see Justice Keller has a question.
Thank you, counsel. Justice Keller.
Thank you, Chief. Attorney Doss, wouldn't she be too late? Wouldn't she have to actually file something to get her seat maintained? And wouldn't the time limitations have already run?
Yeah, Your Honor, that's the point the plaintiff's making. A great question, because what's unique about the minority representation statute is it actually ties the races together. So once the plaintiff has asserted this claim with respect to the 1-year seat, the statute itself says that seat is deemed filled first. So we have to determine then whether or not Ms. O'Shea would get that seat. And if that's the case, it would knock out one of the Democrats, because for purposes of the minority representation statute, under these facts, Ms. O'Shea is a Democratic member.
All right, thank you.
Your Honor, with that, I think the statutory scheme is clear. Ms. O'Shea is a Democratic member. If she were to take the one-year seat, only 2 Democrats could have been elected to the 3-year seats. Ms. Hammond should either hold the 1-year seat or the 3-year seat, but she should not be affected by the litigation and her membership on the board. And unless there are any further questions, I'll just rest on our brief.
I see no questions. Thank you, Attorney Doss.
Thank you.
Attorney Esses?
Thank you, Your Honor. Joshua Estes, pro se intervener. Your Honor, the plaintiff seeks to paint myself and Ms. Hammond as sore losers seeking to undo unfavorable election results. But that's totally the wrong story here, and I wanted to take just a minute to make sure you have the right story. The state statutes call for diverse viewpoints on the Board of Education. That's what the minority representation rules provide for. We want what's in the best interests of the residents, and that includes making sure the entire community is represented on citywide elected boards. When I saw an absentee ballot in early October with the disputed 1-year special election, as well as the plaintiff's attempt to circumvent minority representation rules by changing party affiliation from Democrat to unaffiliated, I knew the community was at risk of not having diverse viewpoints represented. I also knew that, pursuant to our charter, that special election wasn't scheduled to occur, and I promptly informed the city of this issue. In the meantime, I registered as a write-in candidate to preserve my ability to run for the special election if the city allowed this violation of the law to continue. But to the city's absolute credit, the city has defended the law and our charter, and there was no need to run as a write-in candidate for an election that didn't exist. My position today is the same as it was back in October. There was no valid election for any 1-year term on the Board of Education. In conclusion, it's important that you affirm the trial court today, not only because the trial court was right as a matter of law, but because in doing so, you will ensure that Stanford's diverse viewpoints and backgrounds are represented on the Board of Education, thus making our Board of Education better for the teachers, the students, and the entire Stanford community. Thank you.
Thank you, counsel. 1 second, please. I believe at this time it would be appropriate for Justice McDonald, the questions you have for the Attorney General's office.
Thank you, Chief. Attorney Osborne, I directed my questions preliminarily to Attorney Baer so that you would have a preview of what my question was, so that I wasn't catching you completely off guard, because I know you did not file a brief in the case, but you heard the sum and substance of it. And I understand that the Corporation Counsel was doing the best she could under the circumstances. She sought guidance from the Secretary of State's office, and she was relaying the guidance received from the Secretary's office. But for the life of me, I don't understand what the authority is for a moderator who has a report of votes cast in an election to not certify those votes as legally cast votes. Whether the position can be legally filled is a separate issue, but there's no question that the votes were cast. So how can they not have to be reported to the Secretary's office?
Thank you. I think that the Secretary's position is similar to what Mr. Baer said earlier. I think we take issue with your determination that votes are lawfully cast if there's no election for which they are being cast. So I think that the Secretary obviously was in a situation where she was dealing with a very confused and probably very unusual situation. And the purpose of the submitting returns to the Secretary, it's not intended to be a narrative of what occurred in the polling place on that day or a narrative of what went on in the election. It's certifying vote totals for who will be potentially certified as the winner of an election. So returns in the statute, the statutes 9-3, 12, 313, 314, they discuss the returns that are required under the chapter. And so it just, in faced with a situation, a very unusual situation where you have an office, a write-in office, so where there aren't even candidate names on it, on the ballot, that isn't supposed to be on the ballot in the first instance, according to the corporation counsel of the town. The secretary's opinion was, an assessment was at the time, that only compounds the confusion to take this formal step of filing returns, which are about elections, not what happened or not what somebody wrote on a ballot. So for an example, if Ms. O'Shea had never properly registered as a write-in candidate in this case, which she did register as a write-in candidate, but had she not, even if people had written her name in, those would not have been votes. So
right, but the reliance or the statute that Attorney Baer cited, 9-256, is actually takes place before anything actually is sent to a voter. It is a sample ballot sent to the secretary for her review. Once approved by the secretary, that is then distributed by the town to absentee ballots, and all the rest of it. So the secretary approved the ballot. The secretary approved the registration of these individuals, all three of them, as write-in candidates. So it was an approved ballot with approved candidates to be write-in people. And I still am not hearing what the authority is for not reporting accurately the votes cast for people who are properly registered as write-in candidates.
Well, just to clarify, the language of 9-256 pertains to the submission of a sample ballot to the secretary within 10 days of the election. And right. 9-135 small b and then sub e is really where the whole election started, where a sample ballot of the absentee ballot was given to the secretary within 10 days of the commencement of absentee balloting. So that would have been in September. And at that time, the secretary received that, didn't determine, there was no discussion at that time that there was any error on that ballot. That's the ballot that got printed with the incorrect column 9 for a write-in for this office. And then subsequently in mid-October, after absentee voting is already underway, after thousands of ballots have already been printed, after Stamford voters have received absentee ballots in the mail, there were 60,000 voters in Stamford in 2020, and 1/3 of them voted by absentee ballot. So the election is already underway at that point, and the secretary is faced with a situation where midstream and very late actually in the election, she's advised that there is now an error on the ballot. And so she, under the statute, both 9-256 and 9-135 small b, she has the discretion to, she shall order the election official to print a new ballot or other measures that she deems appropriate. Here, she deemed it appropriate to not completely disrupt the 2020 election while that was already ongoing. So just to take these facts, if the secretary were to have ordered the town to have reprinted ballots on October 16th, as a practical matter, the order wouldn't have gone out that day. They would have had to order them again. They would have had to be reprinted, and they wouldn't be in the mail until the end of October. And we had a situation where the United States Mail wasn't even processing the ballots that we had mailed out on October 1st. So that's what she deemed appropriate, was to not disrupt that election. And then she followed the guidance of the town corporation council, much like in Cook-Lippmann. If you look at the facts at Cook-Lippmann at 763, I think it is, again, Mr. Bromley gives an opinion. Somebody disagrees with that, and Mr. Bromley in the Secretary of State's office says in Cook-Lippmann, well, the charter controls, and we don't determine issues regarding the charter. So here we have town council telling us we don't have a valid election. Well, why would the secretary want to receive returns for an election that's not supposed to be taking place? And if one last point, and I'll stop, but if you then put on top of that, you've got a minority representation statute 9-167, which directs the clerk in sub C of that statute to do the ranking of who should actually fill this office. So arguably under 167, it's really the clerk that's going to be assessing who the winner of the office is, because the clerk undertakes the ranking. So the secretary doesn't get involved in that process either. So I guess that's the answer to the question. There was no reason why these election results, if the town thought they should be processed, couldn't have been given to the town clerk for her ranking and determining, as Mr. Doss has argued, whether Ms. O'Shea properly should be entitled to this office based on the minority representation statute.
Okay, I won't belabor this much more. I mean, the language of 9-256 is very clear that the secretary can order the registrars to reprint from the sample ballot, not from a final ballot that's been distributed to voters. It's the sample ballot that's sent to her. But let me just put the final point on it, because the whole discussion assumes the conclusion that this office wasn't properly on the ballot. If we were to agree with Attorney Lydon that his client was properly on the ballot and won this election, or should have had the election count, and we have three candidates who have certified votes of 0, 0, 0, who's won the election?
Well, you would have to, if this court thought it becomes a question of relief, and then to just, in no instance is the secretary in this particular scenario certifying any winner because of the minority representation issue. So, so if you look at that 9-167 that's discussed in Ms. Heyman's brief, that has in subsection C, you'll see it's the town clerk that undertakes the analysis of, it's the unusual situation where the person with the most votes doesn't necessarily get to take the seat. So the secretary isn't involved in certifying a winner here at all. If you want to order her to receive some vote returns, she has no objection to that. She thought it was a better approach to not compound the confusion that surrounded this whole situation by then taking vote returns for an election that is a nullity. Much like in Cook-Lippmann, the petitions that were filed with the town clerk to order the special election, or even the special election that did occur, were concluded to be a legal nullity. So that was her approach in what was an unfortunate situation.
I appreciate your answers, counsel, and I certainly appreciate you being here. I know you hadn't filed a brief, so I was relying on your understanding of the law based on your years of experience, and I appreciate your answers.
Thank you, Justice McDonald. Justice Ecker has a question.
Yes, I've also been thinking about 9-256 and its role here and the secretary's role in the case. You know, the city has, to some extent, although it claims, it's mostly about the charter and home rule, has taken some cover in pronouncements by the Secretary of State, however informal, about what's appropriate and what's not appropriate under this statute. And I just have similar questions about whether the statute has any application here, really. You know, it does seem to be dealing with a question of a sample ballot prior to the publication and publishing of the ballots. And it also, you know, I also wonder, and I guess this is my question, because you've already answered about the samples, but the reference to an error in that statute, it's just a little, it's an open question in my mind whether that kind of error refers to what happened here. I mean, because it says Secretary shall examine the sample ballot required to be filed, and if such sample ballot contains an error, the implication there is that the error would be something that would come to the attention of the Secretary rather than be brought to its attention from some exogenous source. Maybe somebody's on the ballot who hasn't properly registered and so forth. Do you dispute that reading?
No, I think that the purpose of the sample ballot that's provided to the Secretary for her review in 9-256, I think it says within 10 days of the election. So that would have this year been within 10 days of the general election of November 3rd. 9-135, I think it's small b. That's really where all the action is here, because that sample ballot would have been reviewed by the Secretary in September. And that was where the risk of disenfranchisement was flowing come mid-October.
So whatever communications took place between the town, the city, and the Secretary or her delegate, you know, about what the appropriate course of action was once this came to light, that wasn't done by the Secretary under the authority of 9-256. The actions taken by the Secretary weren't under the authority of that statute, were they?
Well, here the Secretary really took no actions formally. So, you know, she is the chief election official of the state. She tries to offer guidance to town election officials, even if it is informal like it was here. But her review of the sample ballots, like you indicated in the normal situation, is, you know, hypothetically, a candidate could be Jane, you know, R. Smith, and that could be her actual name. But when the town prints the ballot, it's Jane Q. Smith. So that is technically an error that the Secretary might see upon review of the sample ballot. Or another situation where we've had cases where minor parties or political parties have to be listed in a certain order of priority for an office. The Secretary oversees the makeup of the ballot and how candidates should appear in terms of ranking. She could see that on the face of a sample ballot and correct that. Here, she had the unusual situation where an error that does not appear on the face of the ballot is brought to her attention. So I don't want to say that she cannot rely ever on extraneous information. Here, information provided by election officials and corporation counsel to her to then order a correction. Here, she deemed it appropriate to not disrupt the election, and the statute gives her that authority as well.
Okay, thank you very much.
Thank you, Justice Eckert. Thank you, Assistant Attorney General Osborne. I know these were very unusual circumstances for you to be here. We appreciate you coming in today. And thank you, and thank you to the Attorney General for indulging us. We greatly appreciate it.
Oh, thank you. I hope I was of some assistance. Thank you.
You were. Attorney Lydon?
Thank you, Your Honor. You heard from Attorney Esses and Hammond's counsel about the things that they did when they found out that this was on the ballot, and they wrote in for the right on themselves to protect themselves, and then they tried to get this decision from the corporation counsel. What they did not do, when apprised by their own admission of a ruling of an election official putting this on the ballot, was bring a claim under 9328 to court, where my client would have gotten notice and an opportunity to be heard as to how this should be construed. Instead, they sat on their rights, and then challenge this after the fact.
Attorney Lydon, there's a question from Justice Doria.
Okay.
And then Justice Khan.
I'm not following that, Attorney Lydon. When should they have brought an action? Before the election?
When they knew this was on the ballot. And not only do they admit they knew it, they signed on to be candidates themselves while claiming this election shouldn't be on the ballot.
Well, you didn't bring an action either once the Corporation Council ruled as she ruled, and nobody's holding that against you.
Because the Corporation Council is not an election official whose ruling I can bring a challenge to under 9328. It's a non-binding opinion that was not being followed. When I first found out and was brought into this case was after that the Corporation Council opinion. And then I said, are the electors gonna be counted? And we were told, yes, the registrars are saying we're going to count the votes. And I'm not talking off the record here because that's what Attorney Emmett certified in her affidavit. Until 3 days after the election day, they were going to count these votes. There was no ruling.
Let me ask you this. Under what circumstances could it possibly be the remedy that your client would get the benefit of a win under 328? Or I guess my question more directly should be, if you're right, if we were to agree with you, wouldn't there have to be, or wouldn't a judge likely order a new election for the vacancy?
No, I disagree with that, and that's the case that I cite where no candidate's entitled to an electoral equivalent of a mulligan. This court has been clear on that.
It's no. It's not the question of the candidate. It's the question of the court certainly under 328 has the authority to order a new election, order a change to the election schedule, and the people that the court would have in mind would be the electorate, who, I mean, if anything is clear on both sides of this, there was confusion. So I'm having trouble understanding how you'd think that necessarily this would result in your write-in ballots allowing you to, I mean, I guess it could be the remedy, but it's not necessarily the remedy. You disagree with that? You think it's got to be that your client gets the office?
I guess I don't disagree with that because ultimately it's this court's decision. But in the case law determining whether remedy is certify the election that happened or order a new election, the weight is towards certify the election that happened. And I think it's important to correct what was stated by Justice Keller, that the major parties were denied the right to participate in this election. That is clearly incorrect. They chose not to, and it's not clearly in the record, but it's kind of. But
I guess my only point off of that question that I'd like your response to is, what does timing have to do with any of that? I mean, quo warrantos could be brought off after the election at any time by anybody, your client or anybody else, and nobody asked the question of whether you did this beforehand or after. That's essentially what your action is a quo warranto. So I'm having trouble understanding why timing is held against anybody, candidate or the town or anyone.
It's on page 9 of my reply brief. Price v. Independent Party would be the clearest case. That waiting weeks with knowledge of this issue without bringing a claim in court where all parties would have gotten notice and opportunity to be heard waives your right to do it. And that delay is inexcusable. So this court has held that specifically for doing so. So I think an election happened. It was a proper election. While there was some confusion, that day is never going to come again. And that's what the case law goes into that weighs against calling a new election, particularly in the instance where it's a 1-year special election. I mean, when are we going to have it? In like September? After Attorney Doss says we're supposed to first have a new hearing, talking about another election that's not even before this court. At some point, they're kind of running out the clock. They knew about this issue. They didn't go to court, and that is a waiver. The Cook-Littman case cannot possibly control the constitutional issues when literally no constitutional issues are raised. The other thing in Cook-Littman that's important is that election occurred while the appeal was pending, and the objecting party filed an emergency stay motion to this court, which was denied, and it got ruled on later. So all parties did all they could to protect their rights, and then the court later undid it. That's very different when these parties knew about the issue, watched the election go by, registered for that election, and are saying, don't count that election now because we don't like the outcome. And then the only thing that I thought with the city's explanation as to the rational basis, the best I can analogize it to is the Nixon-Frost thing, that if the president does it, it is not illegal. That's kind of all they're saying. Like, if it's in the charter, it can't be unconstitutional. That can't be. We have to weigh these issues that are weighty issues. I see my time is up.
Thank you, Attorney Lydon. There's a question from Justice Khan, and then I have one.
Thank you, Chief. You're all right if I go first?
Yes, Justice Khan.
Okay, thank you. Attorney Lydon, my question is, I raised my hand because you said your client never got notice, and you argued that in your brief. But your opponents point out that your client did get notice, and that, in fact, there were 2 meetings that your client attended. And Attorney Baer, in his response to, I believe, Justice Ecker's question, indicated that as soon as the Corporation Counsel had a legal opinion, it was posted and the public was notified of it. Are you saying that, are you alleging that the Corporation Counsel's office sat on an opinion and delayed publication of it? Do you dispute that?
No, and to be very clear, we were given notice that a decision adverse to us had been made. That's very different from notice and opportunity to be heard before the decision is made. To state those are equal to each other just throws due process on its head. And 2, that was simply the non-binding Corporation Counsel opinion, which the registrars and the officials we were being told we're not going to follow. The moderator's decision to certify 0, we got no notice of.
But that's not my question. My question is, are you claiming that the Corporation Counsel's office sat on information purposefully? Are you claiming that they delayed, that there was some sort of undue delay between the time this issue was raised, which I guess Mr. Essie said he raised it. Are you saying there was a delay between the time it was raised and when your client was notified through the Corporation Counsel's opinion?
No, and the Corporation Counsel isn't a part of these proceedings. An opinion was rendered. Yeah,
that's not my point, Counsel. My point is simply notice. But I think you've answered my question. You're not suggesting that they delayed in terms of releasing their opinion.
No, they promptly told us after the fact what their decision was. I think that's a fair statement.
That's I get that point, but you're not claiming that they unduly delayed the notification of that opinion, whether or not they involved your client beforehand. You're not claiming, correct? Okay.
Yes.
Thank you, Counsel. I'm yield back to the Chief.
Thank you, Justice Khan. Attorney Lydon, Justice McDonald asked you a couple of questions concerning the rational basis for the charter provision and interpretation of what biennial means. And you seem to concede that there could be a rational basis. I then had a discussion with Attorney Baer about that rational basis. Did you concede that there is a rational basis?
No. What Justice McDonald asked me about, and I'm assuming his facts are correct, that for Board of Reps, there could be a situation there would be what I'd call administrative burden on having that election in that scenario. Which would explain it for that election. That would not translate to Board of Ed when it's on the ballot, when there's no administrative burden whatsoever to not have the election. So while there might be one in a case that's not before us, assuming facts are correct that was stated in the hypothetical, that doesn't answer the question before us, the Board of Ed, when to date, no rational basis has been offered other than biennial means odd, and since it's in the charter, that's the rational basis.
So if during our deliberations we were discussing this matter and we could come up with a rational basis, then what?
I think it's the obligation on the party defending them to proffer the rational basis, or at least I would say principles due process would require we be notified of that, and I get to weigh in on whether it is or not. I don't think the court's supposed to just sort of come up with that when the defending party has not. But certainly, if that were to happen, it seems to me it ought to be a matter of supplemental briefing and argument, rather than read for the first time, kind of like we did the head moderator's decision to avoid the vote.
Okay, thank you. Well, there's a few things in this case that seem to be in an unusual posture. So what I think we'd like to do is we're going to go into the virtual conference room. We may be able to come to a point where we can announce something to the party. So I'm going to ask you to stand by for a little while until the clerk calls you and lets you know otherwise. The stream will stay open, but I don't think the YouTube part of the stream will. But I don't know the answer to that question. So if you can hang on, I greatly appreciate it. All right, with that, I will join the judge. Okay, I believe we are all back. Can counsel hear me? Madam Monitor, can we go back on the record?
We are on the record, Your Honor.
Thank you very much. I appreciate everyone for coming in doing this. There were some unusual things about this hearing, and so I greatly appreciate the attorneys being flexible and quite frankly, nimble on your feet. We try not to give you that kind of a challenge, but occasionally it happens. We have conference in the conference room with these kinds of cases. We try to get our decisions out quickly, but we also try to do them, make sure that we have them absolutely right. We feel that we are able to do that in this particular case, so we are ready to render a decision from the bench. After deliberations, the court has decided that the judgment shall be affirmed and an written opinion will follow. Thank you very much. We appreciate everything that everybody did. Good luck to you all, and we are adjourned without date. Take care.
Thank you, Your Honor.